And so the question then becomes under the Second Amendment, is the firearm under consideration one that could be used for a militia purpose? If it could be used for a militia purpose, then it's protected by the Second Amendment. End of discussion.
Reluctant Preppers provides educational awareness and commentary only. Opinions expressed do not constitute personalized financial advice. Viewers are encouraged to do their own research and seek qualified personal financial consultation before making investment decisions.
As a responsible person with growing concerns for your privacy and personal liberty, you want to know where we're headed and what you can do about it. We ask the experts what you need to do to take prudent and responsible action to safeguard your family's wealth and well-being, and what basic first steps will help you to be aware and prepared. ReluctantPreppers.com.
Welcome back, Reluctant Preppers. We're always glad to have this returning guest. Dr. Edwin Vieira is a constitutional scholar. He has been with us here a couple of times in the past talking about what the Second Amendment to the Constitution really means and what our rights and responsibilities are under it. Dr. Vieira, thank you for joining us again here on Reluctant Preppers.
Well, it's my pleasure to be with you.
I thought to call you back and ask you on the show again because there was a series of articles that came out just last week talking about a growing number of counties, cities, and even some states that are passing legislation or who are making announcements and pronouncements in defense of individual gun ownership and to protect citizens from the potential of overreach by federal legislation or rules or policies or executive orders that might come down the road to limit or restrict people's ability to own firearms. So we wanted to have you back on to help set the stage for us and make sure we're looking at this in the right context of what is the reality, both historically and legally, currently, for what's happening to protect individual gun rights on these various local levels.
Well, let's understand the primary principle here is that a statute, whether it's passed by the Congress or by a state legislature or perhaps an ordinance passed by some county board of supervisors or whatever the local jurisdiction would be, which violates the Constitution, is not a law at all. It doesn't require obedience. It can't be enforced. In principle, of course, the people who pass it will attempt to enforce it. But in principle, it's not really there at all. It's a blank piece of paper in the legislative book. So, in principle, what some of these lower levels on the organizational chart, at least, talking about counties or sheriffs within a county, the number of those that have come up, that are declaring their particular areas sanctuaries for firearms rights, or the sheriff saying that they will refuse to enforce various kinds of prohibitive legislation that's coming out of the state legislature. Or most recently, I think the state of Missouri passed a statute that is reported to deny the legitimacy of various federal gun control statutes.
Mm-hmm.
A few years ago, there were a couple of statutes passed, one in Montana and one in Tennessee, I believe, that tried to circumvent, let's say, federal gun laws by declaring that if a firearm was manufactured entirely within the state of Montana or Tennessee, that it could not be regulated by the federal government because it was not involved in interstate commerce. And that's the basis on which the federal government, at least, has attempted to pass gun control legislation. It's all dealing with interstate commerce and firearms. So if a firearm travels in interstate commerce, Congress declares that it has the power to attach certain kinds of regulations, prohibitions, whatever, to that particular statute. They're not attaching it to the individual who might purchase it. They're not attaching to the gun dealer who might sell it directly, but they're attaching it to the firearm. So this, the theory that these legislators had in Montana and Tennessee was, well, if the guns were entirely manufactured within the state, then they wouldn't be involved in interstate commerce, then they wouldn't be subject to regulation. The problem with that is that the Interstate Commerce Clause has been so misconstrued by the Supreme Court that essentially everything is involved in interstate commerce. I mean, if you needed a piece of steel or a particular tool in order to make that firearm in Montana. Where did that piece of steel come from? Well, it didn't come from a steel mill in Montana. It came from a steel mill in Pennsylvania, whatever. Where did that tool come from? Well, it came from someplace in Illinois. And therefore, there's this chain of connections, this concatenation of interstate commerce that eventually gets you back to the thing that you're making in that garage in Montana. So one could have predicted that the federal courts at least would say, oh, no, interstate commerce is so pervasive that you really cannot possibly create a situation where you could get out from under that type of regulation. Now, the other extreme here, I shouldn't say extreme, the other part of the other end of the spectrum is dealing with regulations coming out of the state legislatures primarily, which say that individuals cannot own, cannot possess, certainly, but in some cases, I think in New Jersey says you can't even own one, certain kinds of firearms. And they designate these as assault weapons and all these names that they use and then descriptions that they set out. And what they call high-capacity magazines, which is another misnomer because what's the normal capacity? Right? If you say high, there has to be a low. What's the low? I mean, it's nonsense. But anyway, they have these lists of prohibited firearms. And they are subject to regulation in New York. That's the way it's run there. They're subject to prohibition in New Jersey and Maryland. They're subject to all sorts of regulation verging on prohibition in places like Massachusetts and Connecticut. So the question then is, these laws, supposed laws, are coming out of the state legislatures. Need they be enforceable in the sense of the lower levels in the government actually taking action? Because it's not the legislators that enforce these laws. It's going to be the local police, local sheriffs, whoever will be called upon to go and confiscate the firearms from people who refuse to turn them over or to register them, whatever the regulation may be. And what you're seeing in those states, I mean, New Jersey and New York are classic examples of this. They think there are hundreds of thousands of those firearms that are subject to these various laws that are in the possession of private citizens, and who's turning them in? Well, a very, very small percentage, apparently, of people turning them in. And now the question becomes, well, what are the state authorities going to do? Are they going to attempt to go house to house, use whatever records they may have of purchases of firearms to confiscate them? So the problem then arises, who's going to do that? Well, it will be the local police. I mean, it might be the state police in some instances, but more likely it will be the local police forces and the county sheriffs. So you have county sheriffs, I think it's in Oregon now, Washington State, maybe both of them because they're equally liberal in terms of gun control. A number of the sheriffs are saying, well, no, our counties are going to be sanctuary counties. We're not going to enforce these prohibitions on certain types of firearms because they're protected by the Second Amendment. So that, of course, is the situation that you had in this country in 1775 in Massachusetts. You had General Gage as the military governor of Boston, and then you had all of the local people in the various counties on the outskirts of Boston. And General Gage was intent upon confiscating as much as he could of the weaponry, firearms, and primarily ammunition that the colonists had, the Massachusetts Bay colonists had. And the locals simply would not go along with him. He could find no assistance, shall we put it, from the local authorities in the various counties and towns, to the extent that he put out an order prohibiting town meetings. They were so subversive that they couldn't be allowed to have town governance anymore. So what did he end up having to do? Well, he ended up having to call upon the British regulars that he had in Boston and march them to Lexington and Concord, and everybody knows the result of that. It was the beginning of the War of Independence. So that's kind of a scenario here that some people have in mind that, well, if enough of these local authorities, the local police, the sheriffs, county authorities, just say no, as Nancy Reagan once told us, say no to alcohol and drugs, just say no to gun regulation, to gun confiscation, then what will happen? Will there be some kind of direct conflict that ends up in force against force? And who has the crystal ball about that? But in principle, you look at what these sheriffs are doing, and in principle, they're correct. I mean, they take an oath to the Constitution. They do not take an oath to legislators in Olympia, Washington, or whatever the state capital may be. So if those legislators enact some bill that a sheriff believes in good conscience is in violation of the Constitution, what is the sheriff to do but to obey his oath to the Constitution? That's the federalism structure that we have here. I mean, on top of the whole thing is the Constitution, and everyone below the Constitution takes an oath to support and defend it, whatever the language may be. And that oath is higher than some other determination that some public official may make, that passing a particular statute or promulgating a judicial opinion or whatever is consistent with the Constitution. So we're getting into a situation where the proverbial stuff is going to hit the proverbial fan, because the legislators in the blue states, as they're so-called, the states that have, what shall I say, kind of a totalitarian mindset in their legislatures, are hell-bent on doing everything they can to remove as many guns from as many hands as quickly and thoroughly as possible in this country. And you look at Maryland and New Jersey being perhaps even worse than California, because California has all sorts of ridiculous regulations dealing with what they call assault firearms, whether they can have removable magazines of this capacity, whether they can have pistol grips, on and on that goes. They simply banned them in Maryland and New Jersey. Right? There's absolute prohibition on that. And the unfortunate thing is, some of the courts have upheld it. The Maryland law in particular was upheld in what I would call a notorious decision, Colby versus Hogan, the Fourth Circuit Court of Appeals, which covers Maryland, West Virginia, and the Carolinas, upheld that Maryland ban on the theory that, well, these assault firearms, what they call assault firearms, were very similar to, they were akin to the type of firearms used by the regular armed forces, the Army and the Marines. And therefore they were, quote-unquote, weapons of war. And being weapons of war, they're not protected by the Second Amendment. Well, if you think about that, I'm not sure what weapon has not been used as a weapon of war under some circumstances in the course of some kind of warfare. Mm-hmm. Right? I mean, even if you get down to the lowest level of partisan or guerrilla warfare, where you might be talking about a six-shot revolver or the famous Liberator pistol. That was, I'm sure some of your listeners know about that one, which was this little sheet metal handgun designed to be airdropped to resistance fighters in Europe during the period of the Nazi occupation. And the idea was the resistance fighter would take this cheap little gun, didn't even have a rifled barrel, and use it to shoot some German soldier and get a better gun. So even that thing was a weapon of war. That was made by the guide lamp division of General Motors, the people that made automobile headlights, because they knew how to make things out of pressed steel. So that theory that was put out by the Fourth Circuit Court of Appeals would embrace essentially anything that a legislator wanted to call a weapon of war, and historically you could probably tie almost any modern firearm to some recent war or war going on at the present time. So that's what we have here. We have a group of legislators in various states who are hell-bent on, let's not say repealing the Second Amendment, because they can't do that, but nullifying it through legislation. And you have a number of courts that are willing to go along with them, and the Supreme Court doesn't take very many cases. They took one recently dealing with the New York City ordinance that prohibits people from taking, even if you have a licensed handgun, which is difficult enough to get in New York City, you're not allowed to take that out of the city. So if you want to go target shooting or target practice, what have you, you have to use one of the target ranges that are within the boundaries of New York City. And some of the people made the argument, well, wait a minute, I may want to go to a target range that's outside of New York City, or I live in New York City, but I have a second home in upstate New York, and I want to take my gun there for protection on perfectly lawful possession of that firearm there, but I can't do it because of this New York City ordinance. So somehow or other, for some reason, I'm not sure, the Supreme Court took that case, and we will be getting a decision out of them on that. And I say I'm not sure why they took it, because that's really a peculiar ordinance. I can't imagine that there are very many other cities that would have anything like that, almost something that's unique to New York City. So why they took it, I'm not sure. Now, there happens to be a federal statute that says if you possess a gun in one place and you take it to another place where you may lawfully possess it, you can't be prohibited from doing that as long as the firearm is unloaded, it's in the trunk of your car, and the ammunition is in a separate container, and it's all locked, right? So one would say, well, if I'm in New York City and I can lawfully possess the gun there because I have some kind of New York City license, and I want to go up to Albany or whatever, upstate New York, where I can lawfully possess the gun and I have a home up there, I should be covered by that statute. Or what if I was in New York City and I wanted to drive to Vermont, or I wanted to drive to New Hampshire where there are really no prohibitions whatsoever. I want to go up there to a gun show, or I want to go up there to Gunsmith, or I want to go up there to a shooting contest. Well, this New York statute would stop it. So maybe they're going to deal with that kind of transportation commerce type problem. Well, we'll see. I mean, I look at that statute and I say the thing is so full of, that one is so full of holes that there's about a dozen different ways it could be declared unconstitutional. But these others are the ones that are more interesting because they look directly to classes of firearms, and it's usually the term assault firearm, the AR-15, the AK-47, those are the archetypical assault firearms that these statutes cover. And they say, well, you can't own these. Private individual cannot own these. Or, if you own them, then they have to be registered with whatever, the state police, I think it is in New York. And then you cannot have certain kinds of accessories with them. You can't have magazines that have whatever it is, over 10 rounds. That's typical, the 10-round magazine limit, and you can't have flash hiders. In some instances, you can't have a pistol grip. You can't have the folding stock. You can't have a bayonet lug. A lot of criminals, of course, are, they hold up 7-Elevens with a bayoneted rifle. I mean, think about this. It's just nonsense. But what it comes back to, see, the gun prohibitionist people are a lot smarter, in a sense, than the Second Amendment people. Because if you look at the characteristics of the typical assault rifle definition, they are talking about a military-grade rifle. And I don't care about this distinction between semi-automatic and full automatic. Right? Because anyone who goes to a range and actually shoots those guns knows that you can shoot a semi-automatic very, very quickly with more accuracy than the full automatic. Full automatic is the spray and pray theory of shooting, right? Suppression by fire, as opposed to the rifleman theory. You shoot at definite targets, and you don't waste your ammunition, and then find yourself, needing to use a bayonet. So the gun prohibitionists they're targeting this thing, this category, which is the military-grade, essentially military-grade firearm. And that's what the Colby case said. They said, well, these things are equivalent to weapons of war. What's the real distinction between the AR-15 and the M whatever, M4, M16, whatever is the designation that the Marines and the Army use? Well, it's the absence of burst fire. Right? The AR-15 is a single shot, unless you know how to bump fire it, and then it becomes very, very close in rate of fire to a, fully automatic. So I mean, it's all nonsense, right? But they understand that what they want to do is they want to prevent people from having the kind of firearms that would allow them to function, enable them to function in a militia structure, an honest-to-gosh paramilitary/military structure, an organization. I don't think they really care. I mean, ultimately, they'll try to dispossess people of all firearms. I mean, they want people to be totally at the mercy of the totalitarian state. But there'll be a long period of time in which they say, well, you can have a revolver and so forth. You can have these second-rate type firearms. But they want to dispossess people of the firearms that would be, from a constitutional point of view, militia firearms. Right? The firearms that people have not only a right to have, but actually have a duty to have. And there was a statute that somebody put in, a bill, not a statute yet, and I can't recall off the top of my head which state this fellow put it in. But that statute required everyone in that state, unless he was a conscientious objector, I assume, to possess an AR-15 rifle. So every now and then you see somebody the little light bulb goes on, cartoon character light bulb goes on above the heads of some of these people, and they recognize, well, wait, what is this all really about? This is not about target shooting.
Mm-hmm.
This is not about hunting.
Right.
This is not even about self-defense in your own home.
Right.
It's about this much bigger thing over here. And as you come closer and closer, face to face with this totalitarian mindset that's out there in the Democratic Party, for heaven's sake, and part of the Republican Party as well, you realize that's what this is all about. All right? That's what this is coming to. And the great danger that the other side sees, the gun control people see, is, well, wait a minute, there are, 150 million, 200 million. We have no idea how many firearms are in this country. And we have no idea what people will do with those firearms when we, the totalitarians, start cracking down as we intend to crack down. So we have to get firearms away from them. Now, the difficulty with the Second Amendment people is, what they don't realize is that having your AR-15 and your 1,000 rounds of ammunition, or something that's what you have in your cellar, by yourself or with your family, is useless in the long run for really opposing these totalitarians. Because the totalitarians already have large organized forces on their side, at least that they can call upon in principle. Right? What's on the other side? A bunch of totally isolated, disorganized individuals. Well, they may have firearms, they may have a lot of ammunition, but so what? What are they going to do? They probably, the average person who's pretty well armed probably doesn't know enough about his neighbors to be able to believe that they would be trustworthy in a situation where you had this kind of conflict boiling up to the surface. And that's our grave difficulty. Talking about the preppers, what are the preppers prepping for? If what you're prepping for is not some kind of isolated life in the mountains of Montana, but the kind of catastrophic situation of a breakdown in social order because of either the catastrophic EMP. I mean, that's the classic example that's given, right? The grid goes down, and we now find ourselves in the 1200s as opposed to the 21st century, or the 13th century, 14th century, and all the chaos that would cause. Or the political consequences. Imagine now that in 2020, the Democrats win control of both Congress and the White House. And they begin putting in, given what these presidential candidates are already talking about, they begin putting in something like the Alexander Ocasio-Cortez program. Right? Mm-hmm. And the chaos that follows that within probably less than a year. And one of the first things they will do is they will pass the Feinstein gun control bill. Mm-hmm. Right? Except it will make the Feinstein gun control bill look like a peon to the Second Amendment, because once they have all the control there, Congress and the White House, there'll be no holds barred. And then what happens? You begin to think about that. Right? A lot of people will say, just as they're saying now in New York and New Jersey and so forth, I'm not going to comply with this. But I would imagine that the totalitarians will say, well, we have to start making them comply. And so we run into the problem of General Gage and the people of Suffolk County and so forth, Massachusetts, in 1775. Now, the difference between that situation and this situation was General Gage was kind of a piker when it came to totalitarianism. He was a pretty mild-mannered fellow. To think that the colonists in Massachusetts considered him tyrannical in comparison to the ones we have today in Washington and various state capitals. I mean, it's completely, I have to chuckle about it. But opposing him was what? Opposing him was a totally organized society. Right? When the church bells rang and the drums rolled and the warning shots were fired and so forth, and the riders went out, the Paul Revere's and so forth went out, they weren't attempting to reach out to people who were exercising an individual right to keep and bear arms. They were calling forth members of the Massachusetts militia, which was an organization that had been in existence in one form or another since when? 1630-something. 1636, I think.
Okay.
All right? This was a totally organized society. And those people, when they marched to Lexington, to Concord actually, from the outlying towns. This wasn't something they sort of say, oh, gosh, let's do this. It wasn't a matter of individual choice. They were members of this organization. There were statutory provisions that went back through all the way through the 1700s, back into the 1600s, and how these structures were organized. Everyone, of course, was a member from 15 actually in Massachusetts, 15 up till whenever, 50 years old, 55 years old, until you couldn't function physically. So these people recognized that they had a statutory duty. They were a part of a governmental structure, and Gage was the fellow that was stepping outside of what they considered to be the constitutional parameters or the constitutional boundaries that controlled him. That was the reality of that situation. These weren't rebels in the sense that they recognized that what Gage was doing was perfectly legitimate. It was exactly the opposite. They recognized that what Gage was doing was not legitimate, but they were sufficiently organized and trained and equipped so they could stand up to him. Now, our difficulty today is, well, people may have a lot of equipment.
Mm-hmm.
As I say, 100 million, 200 million, how many guns and ammunition and so forth. And they may even be basically trained in some sense. Well, they go to the range every couple of months. They know how to shoot, basically. But that's it. There's no organization whatsoever. We're not even talking about a neighborhood organization. That would be the kind of militia company structure, about 50 people in those units. And they all were in one vicinity, right? Because they all knew each other. They all trained together and so forth and so on. They elected their own officers. It was very much a local operation from the ground up. Well, we don't have anything that even looks like that in this country. Now, if you look at the statutes still refer to this category called the unorganized militia. That's everyone who isn't in the National Guard and everyone who isn't in the armed forces, because if you're in the regular armed forces, you have an exemption from any kind of militia duty. That's everybody else. And at the federal level, that's from 17 to 45. At the state level, well, it would depend on whatever the state statutes. Mm-hmm. But if you followed the constitutional pattern, it would probably be from 16 on up, and there really wouldn't be a limit. They'd say, well, if you get to 50 years old and after that you volunteer, but we're not going to force you because you may have physical problems. But what does that category consist of? Well, it's an empty set. You may be a member of that category. If you're not in the regular armed forces, you're not in the National Guard, then you're part of the unorganized militia. And what do? Well, nothing. What requirements are there? None. Are you told that you have to have a gun? No. Are you told you have to train in some way? No. Are you told you have to have some kind of equipment? No. Are you part of some essentially organized substructure? No. There's nothing there. So this is what Congress has done, and I think very cleverly. It's played this game, and it's put all of the people who are supposed to be armed, trained, organized, disciplined at their local level to do all sorts of things, not simply to fend off tyranny, but to deal with effective natural disasters and all sorts of consequential cataclysms of that nature. It's left us completely at the mercy of fate. We're hostages to fate. Or we're hostages to whatever the tyrants may think they can get away with. And I'll give you the classic example of this, the FEMA people. You look at the FEMA website, and then you look at the state websites of the little FEMAs, and they talk about, well, let's be prepared for 3 days. Have 3 days worth of food and water, and if you need certain kinds of medicine because you're diabetic or whatever, you better have that too. Well, what kind of a catastrophe lasts only 3 days? That's an absurdity, right? Especially if you're talking about one in which classic situation of the hurricane, the tornado, and so forth, where once the catastrophe hits, then you have real social breakdown, looting, and all the rest of the aspects of that kind of disorder. And at the local level, because FEMA is not at the local level, FEMA is totally incompetent at the local level, they try to foist off on us this concept of the community emergency response teams, the CERT teams, so-called. And those depend upon essentially volunteer participation. In some counties here in Virginia, they've got a lot of people, relatively speaking. Not talking about 10 or 15% of the total population, but they have the teams are reasonably large, considering. And in other places, they have essentially no existence. They're paper, entirely on paper. So if you look at this from the quote-unquote prepper point of view, and the goal is to maintain in the long run some semblance of a Republican form of government where the people actually exercise sovereignty under whatever cataclysmic circumstances come to confront them, are we prepared the way the Constitution requires, not just simply allows us, but requires us to be prepared? And the answer is no. And it's all been done, I think, on one hand through stupidity. Right? A lot of these politicians do what they do through stupidity. I think, on the other hand, there's a real plan behind it because they played this word game with the concept of militia. And then they've played on the natural desire of people not to want to bear some burden that they can avoid bearing. Mm-hmm. Right? I mean, that's ultimately what it is. You had a real militia structure in this country, people would be required to do certain things, or they'd be required to pay a certain amount of money in composition for not doing those things. I mean, essentially what they used to do is call them fines, right? You didn't show up for a training session, you paid a fine, all right? So you give an exemption to some people. We have so many people, we don't really need them all to be trained to the same level. And a lot of them would simply pay a fine or pay an exemption fee, and that fee would go to fund the ones who did participate. So you'd have a very large kitty to provide equipment and training for the ones who did participate. And if you had that structure, it, of course, would be compulsory. You either perform this function or you pay this money, one or the other, right? Because we need to have this kind of structure up and running at all times because we don't know what's going to happen necessarily. I mean, the Swiss system, they've had this since the Middle Ages, maybe before the Middle Ages, even earlier, when it goes back to, 1200 or something. And they have basically three levels. They have the what we would call active duty, the Auszug, they call it. And that's the younger people who are physically fit. And so they are trained to a paramilitary or military level. And then you have the Landwehr, which is the next age level. And they're a kind of reserve. And then you have the Landsturm, which is the older people. And they would only be called up in the event of Switzerland being invaded or some other catastrophe occurring. And you could imagine, I mean, there's the three levels. You could imagine any number of levels that you wanted to break the thing down. You could imagine reserves within reserves and so forth, because we have so many people. But the training would be there. And so everyone, when they start off in this country, let's say 13, 14 years old, because your militia duty will start at 16. So 13 or 14, you're in the schools in pre-militia training. Here's what it's all about. Here's why we're doing this. Let's look at the Constitution. Let's look at our history. Let's look at the duties that we have as members of a Republican form of government. And think about a Republican form of government. I mean, people look at the Constitution, and they'll take one part of it, like the Second Amendment, and they'll try to analyze it separately from everything else. Second Amendment begins, a well-regulated militia being necessary to the security of a free state. What's that all about? What is this free state they're talking about? Well, what's interesting is if you go back to the German word, Freistaat, that's one word, free state, literally. The actual translation, generally speaking, is republic. All right? A free state is a republic, a republican form of government. And, of course, that concept appears in Article 4, Section 4 of the Constitution. The United States is required to guarantee to every state in the Union a republican form of government, which means every state in the Union must maintain a republican form of government, or else the other states will come in and make sure that that principle is followed. Well, the Second Amendment is simply telling us if you want that kind of a governmental system, then you need to have a well-regulated militia. And why is that? Because the well-regulated militia is the organization of the entire community basically under arms, if necessary. All right? And that gives the sovereignty to the people, because ultimately what is sovereignty? It's the highest form of coercive power in any society. Those people who exercise the highest form of coercive power, political power goes out of the barrel of the gun, are the sovereigns. And they may be the total population, or they may be a dictator and his cronies and some little army that he has set up, Praetorian Guard or whatever you want to call it. But there will always be, somewhere in that society, some group that holds that supreme power and is therefore the sovereign. In a Republican form of government, the sovereign is the people themselves, and the people themselves hold that power by having a militia structure, because you can't depend upon a standing army. Right? Standing armies have historically turned out to be the tools of tyrants. Mm-hmm. And this is not to criticize the Army of the United States or the Marine Corps or the Navy or whatever, Air Force or so, but that's the reality in the long term. All right? And the Constitution recognizes that, because the militia structure is integral to the Constitution. It talks about the militia of the several states. These are things that already existed. They'd existed for over 100 years before the Constitution was written. And those things are simply there. They can't be removed. Whereas the Army, well, Congress doesn't have to raise and support an Army. It has the power to do so, but doesn't have to do it. One would assume that it would provide a Navy. We probably wouldn't have to worry about a Navy being a tool of tyranny. I mean, what is an aircraft carrier in Norfolk going to do to somebody in Omaha, Nebraska? Probably unlikely. Air Force is one of the armies, right, that Congress raises. But it does, so Congress could say, wait a minute, we don't trust the regular armed forces anymore. We're not going to fund this. It's gone. That's the end of it. No more Army. But they can't get rid of the militia because of the structure of the Constitution. And how could they get rid of the militia, given that the whole structure of the Constitution is based on the Republican form of government, in which the sovereignty is in the hands of the people, and that's proven because they have the ultimate power of force behind them. And this is what most, I think, Second Amendment advocates don't recognize, that we're dealing with a governmental structure here. The Second Amendment is not something that is extra-governmental. They talk about the right to keep and bear arms as being, wasn't given by the Constitution. No, it wasn't given by the Constitution. It was recognized by the Constitution, been there a very long time, as part of the colonial structures of government. It actually derives from the bloody kings. The king would give a charter to some of his favorites to go over and set up a colony. This was their authorization. And in those charters, every one of them gives those people the right, and in fact imposes upon them the duty, to arm and train the inhabitants of this colony that they're setting up in order to defend it against whom? Against the king's enemies, because the king was essentially delegating a little bit of his sovereignty to these favorites that he had to go over and set this territory up, and then it would become part of the British, ultimately the British Empire, right? So it was a governmental operation from the very beginning. Yes, the people who were armed and trained and organized and whatever would be in a position to defend themselves individually. Obviously, if you have a gun, however it is that you end up having that gun, you can use it to defend yourself. But that was not the basic purpose of these structures. The basic purpose of these structures was to defend the plantations, is what they called them, and they became colonies, and they became states, and the whole thing then became the United States, was to defend this territory against enemies, as the phrase goes, foreign or domestic. So the governmental structure. So looking at the Second Amendment, saying, well, this thing applies only to individuals outside of the government. This is us versus the government. All I can say to that is the most naive, if not most nonsensical interpretations you could possibly imagine. The Second Amendment is a recognition that the average Joe from 16 years on up is part of the government. He's the ultimate part of the government. He's sovereign. He's part of the sovereignty which can be exercised through these institutions called the militia. Now, his right to defend himself is, I would call it, ancillary to that. Of course he can defend himself in the same way that he can defend his community. Right? If you have a firearm and you are trained to use it, and some criminal attacks you, you're exercising the right of self-defense. Now, the right of self-defense in English law was always recognized as being, which I say not simply necessary, but being inherent, because in that set of circumstances, there is no one else other than yourself who can execute the law against this criminal. The criminal is attacking you, and that attack is unlawful. And there's no policeman, there's no constable, there's no judge, and so forth and so on, who can intervene at that moment to stop that criminal activity. You are the one who's stopping that criminal activity. So you are the person executing the law against that aggressor at that moment. Right? Well, that's a militia function. Constitution, Article 1, Section 8, Clause 15. Congress has the power to call forth the militia to what? To execute the laws of the Union. That's the first authority and responsibility of the militia. And that's collectively or individually. And at the state level, it would be to execute the laws of the states, because the militia are actually state institutions. Congress can call upon them for certain functions, but they're actually state institutions. And you go all the way down to your local militia company. And that's the way the militia are always structured. Right? The states went all the way down to these local companies. So you are performing, even in that role of self-defense, defending yourself on the street or in your home against someone who's breaking in or someone's attacking you, attempting to rob you. You are performing that militia function. There really is no distinction between the individual right and the militia right, because these people talk about the individual right. They're not talking about target shooting. I have a right to go target shooting. Or I have a right to go hunting. The whole argument that's made by the NRA and all of these groups is, well, the individual has the right to protect himself against some kind of criminal attack. And all I say is, well, when he's doing that, no question that he has that right, but when he's doing that, he is performing a militia function. He's performing a governmental function. And he can perform that governmental function because no other institution of government is there to help him. It really comes down to the individual in that case as the person executing the law. And that's why it's always been recognized as such. You go back to as far back as you want to go with the commentators on English law. That was the understanding. Right? It has to be this way because there's nobody else there who can do it. Right? It's an inherent right because of the nature of the case, nature of the situation. There's nobody else that can do it. Otherwise, of course, the criminal succeeds. Right? If the individual cannot lawfully defend himself up to the point where he actually uses deadly force against the criminal, then the criminal will always succeed and the law will be always broken. So there we have it. Now, there's a problem with the Second Amendment people is they don't see that connection, and so they try to divorce, they do. They divorce what they call the individual right to protect oneself with a firearm from this collective right and actually duty to protect not only oneself, but the community in which one lives with firearms. And the difficulty NRA, for instance, gets into, National Rifle Association, when they do this, is they say, oh, well, we have a right, an individual has a right to protect himself. Okay, he has a right to protect himself. But does that right encompass every type of firearm that could be used for self-protection? That's the argument. That's where you get into the Colby versus Hogan theory. Well, weapons of war, you can't have a weapon of war. Right? You can defend yourself with a handgun. That's the Heller case. Right? You can have a handgun in your home. By the way, Heller still doesn't have his handgun. How long has that case been going on? And he still doesn't have his handgun, which shows you how effective the Supreme Court's decision was. Right? But okay, you can have a gun. But what kind of a gun? And the Colby case says, well, in the Fourth Circuit, Maryland, West Virginia, Virginia, and 2 Carolinas, if the legislature says you can't have an assault rifle, too bad for you, you can't have an assault rifle. Use something else. All right? And that's the difficulty. As soon as you limit the Second Amendment concept to the individual right to self-protection, you get into this argument as, well, what's really necessary? What do you really need to have? Isn't it good enough for you to have a 6-shot revolver, or Joe Biden telling us you have a shotgun?
Shotgun, right.
Yeah, you can have a shotgun. Isn't that good enough, right? You get into these stupid arguments. And I mean stupid in the constitutional sense because they have nothing whatsoever to do with the Constitution. Whereas if you say correctly that the Second Amendment deals with this concept of a militia, we're all members of these organizations in the various states and localities, and we must have whatever firearms are necessary to perform militia functions. Well, what are those functions? Execute the laws. Well, you can think of all the police functions of police-type firearms. Suppress insurrections. Oh, my goodness, what would that include? Repel invasions. Let's start with that one. Those are the 3. Execute the laws, suppress insurrections, repel invasions. Start with repel invasions. What kind of firearms would people need to repel invasions from armies, foreign armies, that were capable of invading the United States? That's all you need to know, because that would encompass essentially every kind of firearm you could imagine. Because these invaders, if they got in, they might gain some territory and so forth, and they would need resistance movements and guerrilla fighters, et cetera, et cetera. Those are the really primitive arms, a Liberator pistol. And on the beaches where you were defending against them, where you'd need a fully automatic rifle. I mean, on and on one goes. And the Supreme Court actually decided this correctly in the Miller case in the late 1930s. That was a case involving the 1934 statute that dealt with machine guns and short-barrel rifles and short-barrel shotguns, and said that you couldn't have these things unless they were registered and you paid a tax. So these two fellows who were actually gangsters, I guess, they were caught with a short-barrel shotgun, and they were prosecuted because they hadn't registered the shotgun and they hadn't paid the tax. And their attorney made a motion to dismiss the indictment on the basis of the Second Amendment. And the district court, trial court, dismissed the indictment without an opinion, so it didn't say why, just dismissed on the basis of the Second Amendment. And the government filed an appeal with the Supreme Court. And if you go to the records of the Supreme Court and look at the brief that government filed, because the other side, the two fellows, they just disappeared. They didn't file anything with the Supreme Court. The government's brief reads like something that comes out of Dianne Feinstein's office or Chuck Schumer's office. They had every gun control argument you could imagine. This is the late 1930s. Mm-hmm. And you would have thought, well, the Supreme Court, on that basis, the Supreme Court might rule for them. Ruled against them. The Supreme Court said, look, here's the reality of the Second Amendment. Let's go back, history, militia structures. Everyone was a member of the militia. Here's the statute in New York, and they had one from Virginia and one from Massachusetts. They give examples. And so the question then becomes, under the Second Amendment, is the firearm under consideration one that could be used for a militia purpose? If it could be used for a militia purpose, then it's protected by the Second Amendment. End of discussion. Okay. Now, what happened in that case, the peculiarity of that case was that the defendants, the fellows who possessed the short-barreled shotgun, had no representation in the Supreme Court. So the Supreme Court looks at this short-barreled shotgun and says, well, we don't know. We can't determine by judicial notice that a short-barreled shotgun could be used for militia purposes. Now, what that means is judicial notice is taking notice of a fact that is so uncontrovertible, all right, that there are 365 days in a year, or a week has 7 days, a month has 4 weeks, whatever, those kinds of facts, right? Gravity, right, et cetera. So they had no evidence. There was no evidence in the record as to the potential uses of this short-barreled shotgun, or even, if you read the Supreme Court opinion, what kind of a shotgun it was, short-barreled shotgun. So we can't decide this on the basis of judicial notice, and therefore we're sending the case back. We're going to reverse it and send it back. And what would have happened in the normal course of events if the two defendants had not been criminals and had absconded, there would have been a hearing in the district court, and evidence would have been produced as to the functionality, usability, whatever, of a short-barreled shotgun in a militia context. Now, in a sense, that decision was a little bit shaky because, shotguns had been used in World War I by the United States Army. Mm-hmm. And it was so notorious that the German army, or the German government, had protested. They said these shotguns were in violation of the Hague Convention. They were like dum-dum bullets. Right? The Hague Convention was against non-jacketed projectiles. And this in a war where they were using poison gas. All right, leave that aside. But the German government protested this. They said shotguns are in violation. So it was notorious that shotguns had been used by the Army of the United States, I suppose the Marine Corps too, because they had Marines in World War I, as trench weapons, right? Trench fighting weapons. So I think maybe if the Supreme Court had really wanted to look, they could have found that that shotgun was usable for militia purposes. But they kind of, fluffed it, sloughed off the what they could have done, just kick the thing back. So let the lower court figure this out. We're not going to bother with it. But the principle is there. That opinion, United States versus Miller, says here's how you interpret the Second Amendment. You have to do it with respect to this thing called the militia, or these things called the militia. And when we look at that, we see, that's everyone organized and trained and armed, and they have to be armed with arms suitable for militia functions. Mm-hmm. So if it's suitable for a militia function. Now, what would that do today? If that test were applied, if that test had been applied in the Heller case, and they go out of their way, Scalia goes out of his way in the Heller case to get around the Miller decision. He doesn't want to hear about the Miller decision. It's amazing. Right? If I were his clerk, I could have written an opinion based on the Miller decision that would have given Heller everything he wanted and a lot more. Right? But Scalia dances around it. He even describes the case incorrectly. Right? You read his description of what happened in that case, it's not right. Okay? So I don't know how that happened, but in any event. But if the Miller decision were used, let's not even talk about interpreting the Constitution, let's just take the decision coming out of that court. What would happen today? Would any of these statutes, Maryland, New York, New Jersey, Massachusetts, California, would any of these statutes be valid? No, because every one of them prohibits in one way or another some firearm or functionality of a firearm that would clearly be usable in a militia context. In fact, the Colby versus Hogan, the most notorious of these lower court decisions, specifically says we're going to allow Maryland to ban these things because they're weapons of war. Well, hell, if they're weapons of war, then they're firearms usable by the militia.
Right.
Right? End of discussion. End of discussion. All of this stuff goes. As soon as you tie that right of the people that keep and bear arms back to the militia, and then from the Second Amendment back into the Constitution, because it's actually in the Constitution, the original Constitution as well, the militia concept. And I have no idea why the NRA and these other gun groups refuse to do that, other than, not invented here. They didn't think of this idea, and they've kind of put themselves in an intellectually untenable position. But getting back to the prepper problem, in the long run, what we face is maintaining, as I said before, the Republican form of government in this country against threats that we see immediately. We're not talking about something 30 years from now or 50 years from now. Alexandria Ocasio-Cortez is there now in Congress. Mm-hmm. Dianne Feinstein is there now in Congress. Chuck Schumer is there now in Congress. And you can go down to a list of these. Adam Schiff, name them. They're there. And we know what they're telling us now, before they have control of the White House, before they have control of the Senate, while they're simply in control of the House of Representatives. They're showing us exactly what they intend to do. And so we're talking about, 2 years? Election comes up in 2020, and then they would come into control in 2021. This isn't 30 years in the future. This is as little as 2 years from now when this will happen. And then what are people going to do? Because the whole prepping concept in the ultimate analysis comes, you're not going to be hiding in a cave somewhere where no one will ever accost you. You're going to find yourself in a situation where there will be a lot of people trying to accost you for one reason or another. And some of them will have badges and guns, as well as being common criminals. They'll be public criminals as well as being private criminals. And then what is going to happen? And the answer is, what is going to happen is going to be a first-class mess unless at some stage and pretty soon people in this country start saying, wait a minute, we have got to go back to the correct interpretation of the militia clauses of the Constitution, the correct interpretation of the Second Amendment. And when we do that, and this is in the at the state governmental level, because the militia of the several states, that's the correct constitutional terminology. When we do this at the state level, in the first place, we get rid of the state gun regulation, and we get rid of the federal gun regulation as well. So the fascinating thing is the power of Congress is the power to provide for organizing, arming, and disciplining the militia. Just take the third word, the power to provide for arming. All right? And what Congress typically does when it passes a statute is disarms people. Mm-hmm. Right? And that's, of course, what the state statutes are doing as well. So at some stage, people have to stand up on their hind legs and say, wait a minute, the Constitution provides for this, and this requires that we, the people, have access through the free market. If the government wanted to produce in public arsenals and deliver them guns to people. That would be fine, but they won't. We have to have access to a free market that will provide us with the firearms that are necessary to maintain a well-regulated militia. And what kind of firearms are those? Oh, well, here's a list of them. Here's the list of the firearms that have been banned in Maryland. Let's just start with that one. All right, that would be good, a good start, right? Here's a list of these things, and we have to have a free market providing this to us. Now, Congress could provide it to us, the state governments could provide it to us, that would be fine, but they're not doing it, and they won't because they don't have state arsenals anymore. And government buys all of its weaponry from commercial firms. So we want a free, and in fact, that's what the situation was in the 1700s. You had some arms coming through the British government and coming through the colonial governments, and they would be sold to people. But the vast majority of people purchased their arms on the private market. And that's why you had the classic situation in Virginia. In the 1780s, they had passed 2 militia statutes, and they specifically say in the statutes, everyone's supposed to be armed, have a musket, and so forth. Powder and shot, blah, blah, there's a long list. Except if you live west of the Blue Ridge Mountains, which is a frontier. And then you can have a rifle.
That's right.
And that was because the people west of the Blue Ridge Mountains had rifles, right? The rifles were better. And so the statutes even recognized this. The technology improved. They said, well, you can have the better technology. So this is the problem. And my concern is that unless this is, how shall I put it, popularized, unless these kinds of concepts are popularized pretty damn soon, to use law French, we may find ourselves in a very sticky wicket, because it is not impossible that the Democrats will gain control of Congress and the White House in 2021. They'll win the election in 2020. Or they need one vote, one more vote, a majority of one in the House, majority of one in the Senate, and some flake, Elizabeth Warren or whatever, as president. And then you can imagine the dam will burst, because you see what they're doing already. Mm-hmm. The dam will burst. And that's, I think, what we really have to be prepared for, and hope that that doesn't happen, at least in the sense that, I guess Trump is the fellow that is already in there, that Trump gets a second term, so that if worse comes to worse, he can at least veto some of this kind of legislation coming out.
Well, it is interesting as these situations are positioning themselves in certain state statutes and in certain federal legislators that are talking about, thinking that way, and even presidential candidates, as you pointed out. But at the same time, there's this litany of counties and cities and even states. There's 3 states, and Kansas being one of them, and Alaska being another, and so on, who are making specific, in Idaho, laws saying that any federal government rule that comes down that abridges the rights of gun ownership will be unenforceable in their states. So we're going to have to circle back with you to talk about this clash of the titans. But you're right, it ends up coming back to the hearts and minds of the individuals. We as the people need to decide whether we're going to rise up and stand up for becoming organized and becoming trained and becoming coordinated, rather than just individuals up against these forces that are arrayed against us. Dr. Vieira, I'm sorry that the time has gotten away from us again, but we're going to have you back on and delve a bit deeper into some of the steps you've talked to us before, of some of the steps that individuals can take, but to see what developments are occurring that are going to make that increasingly urgent going forward. And as always, if you have any final thoughts for our viewers, we'd love to hear that before we let you go.
Well, my final thought is people have to take this general lugubrious picture that I have painted seriously. Take a look at it and say, what are we going to do? This is coming. This is it's here, and potentially within 2 years, it may be right on our doorstep.
Okay.
What are we going to do? It's not enough to say, well, some sheriff or other local official is going to stand up and say he won't enforce such and such laws within his county, because the tyrants will send people in from outside of that county to enforce those laws. The people in that county have to be willing to stand up behind that sheriff in some sense.
Right.
So I need to be thinking about that.
Well, this certainly seems to be coming to a head, and we're glad to
A lot
have
faster
you.
than anyone would have imagined.
That's right, and we're glad to have you helping us to see it clearly and from a correct political perspective, so that we understand truthfully what rights and privileges and obligations and duties that we have, and that we don't get basically cowed under by those thoughts of, it's just for hunting, it's just for protection in your own home or whatever like that. That those are not what the Second Amendment was about. We're always glad to have you clarifying that for us here on Reluctant Preppers, and always glad to have your presence here with us. Dr. Vieira, thank you for joining us again.
Thank you. Bye.
They say the stock market crashed today.
Yeah, I heard that.
Sounds like people's retirement accounts and savings accounts are going to get bailed into the banks.
Yeah.
Looks like pension plans and Social Security are going to get suspended too.
I know.
Sure, I'm glad we decided to put our money into gold and silver instead.
Me too.
Get your first ounce of silver at spot price and free shipping on any order over $99 at sdbullion.com/rp. Hey, Reluctant Preppers. If you haven't heard, we've already started our monthly 1-ounce U.S. Silver Eagle thank you gift to one active Patreon subscriber each month, signed by your host, Dunnigan Kaiser. And you don't want to miss out on that.
Please help us grow by subscribing today at patreon.com/reluctantpreppers.